Constitution of India, a note of Article 14. The Article 14 is clear, unequivocal terms, lays down the law including pre-constitution law which were inconsistent with or derogation of the fundamental rights guaranteed by the Part 3 or 1. Subclass 3 brings into the folds of laws and rules of regulation, notification, customs, and usage having the force of law. Adi Shava Shava Shankarayal Lal Nangam versus Government of Tamil Nadu. The main objective of Article 13 is to secure the paramountcy of the Constitution regarding the fundamental rights. The first clause related to the laws already exist in the force decided pre-constitution laws are avoid to the extent of which it is consistent with the fundamental rights. The second clause related to the proposed constructions and prohibition of the state is making the law, which is a term takes away the totality and abrogates the part of fundamental rights. The expression state is construed in conformity with Article 12 as judicial interpreted. The ambit of the expression law in definition of Article 13, subsection 3, subclause A itself so is ensure that the paramountcy of Constitution extends also to temporary laws such as Ordinance Act as well as permanent laws. Statutory institutions, the nature of and subordinate legislation specifically described as order, by order, rules, regulation, notifications have a temporary of Indian force of law, non-legislature source of law. These are to say, crush usage having territory of India with force in law. Object of the definition of Article 13 ensure that the instruments emanating emanating from the source of law, the permanent or temporary legislation of justice or any other source which pay the homage to the constitution provide relation to the fundamental right. At the same time, the clause 6 ensure constitution amendment does not fall into the definition law in Article 13. It is a validity cannot be challenged on the grounds of violating fundamental right. So the constitution law which violates can't we can't violate the fundamental constitution amendment right. But it should be noted that fundamental right is such a whole is not an immune from the constitution amendment, may in some case a part of theory or basis of feature enunciated in certain decision of Supreme Court. The chronological of important Supreme Court decisions subject to Sandarak. LC Golak Nath, which is state of Punjab. Keshavananda Bharati Sri Padgulavaru, which is state of Kerala, which will uphold the validation of Constitution Amendment Article 13 subsection 4 was inserted laid down theory that there are certain basis features could not be amended under the amendment power. Merwa Mills Limited versus Union of India, which declared that even though the 42 amendments ought to be the amendment of 33 Article 365, there shall be a no limitation whether the constitution power of Parliament is amended by the way of addition, variation, or repeal. The provision of Constitution Act 368, the constitutional amendments relating to the basic features. A total exclusion of judicial review would be void. Okay. Um, Vaman Rao is Union of India. Reaffirmation of the limitation of the constitution power. Bhim Singh is Union of India. S.P. Gupta is Union of India. Or the both being decisions which is upholding the validation of particular amendment, implementing procedure on the proposition of the constitution amendment cannot override basic feature. Fairman Shah in law. The Fairman Shah in law decision taken by the state government as in carried in force of law within the meaning Article 13 subclass 13A the Constitution State of Punjab is Ahmed Alame Latnar Das Chala Mahani Naromas Das. Oh wow. Patilia. Okay, law of lender. Okay, there are some Act of Parliament. We'll see next part. doctrine of feature basis. It's a content of our constitution does not apply to ordinary legislation. They have it ordinary legislation which has come to dual criteria to meet. It should related to matter within the competent. It should not violate an Article 13 or unreasonable restriction on the fundamental right as being the repugnant to express in constitutional prohibition. The basic structure of theory imposes limitation on the power of parliament to amend the constitution. An amendment to the constitution under the Article 368 could be challenged on the grounds of violation of basic structure of constitution. On orders to legislation cannot be challenged. Kuldeep Nair vs. Union of India. Art of State. The state of Haryana, Amarnath Prasad. It has been held that the result of govern entered into the rules of state that has established a new sovereignty over the territory comprises state of rulers. The government and therefore is act as a state which is regarded the act of state. The law is settled. Residents of the territory which is acquired do not carry out with the right which is possession of the subject on the sovereignty. As a result, it's a new sovereign that the process only such a right is granted as a recognition of the act. Basic feature. The basic feature of the Constitution cannot be amended by exercising the power of Amendment Act 1968. The Constitution Act 1976, which inserted in the Article 368, Part 5, provided there is no limitation in the constitution power of the Parliament to amend the Constitution, has been invalid by the Supreme Court adhering doctrine of basic feature. Therefore, the fundamental right of search is not immune from the amendment of N. Balak. Particular right of parts, therefore, it held by the basic feature. See the undermentioned case. Keshwananda Bharati, Shri Padma Garwal, State of Kerala, Miniriva Mills Limited, which is Union of India, Vamanro, which is Union of India, H.S. Srinivasa Raghava, which is State of Kerala. The court was departed on the initial interpretation, so to provide becomes the constitution. It is a literal interpretation, make its provision unconstitutional. Indra Das versus Ayatollah. Severity. When a particular provision of enactment is found to be the void or in violation of the constitution provision, a provision of fundamental right, the question may arise in that impact the finding on the other's provision of the act. The answer to the question depends on the answer to another questions, namely its other provisions immediately connected with the void provision. That each inexhibitly bound up with another, so it can be assumed that legislation would not be enacted in one with an enacting other. Enact one without enacting other. In the other, under the A and B, it's inextricably bound with other. Okay, so severally. Found that when a particular provision of the enactment is found to be void or violating the constitutional provision, the provision of the constitution. The question may arise as that the impact of such finding அதோட எவ்வளோ செயல்படுது on the other provision of the act example. The answer is the question depend on the answer of the another question, namely is the other provision is imminently connected with the void provision. Okay, each is extremely bound up with the other. Amending the legislation would not have been enacted on with enacting the other. State of Bihar, Kameshwara Singh, Jal Trading Co. is mill of Mazor Seba, Kitod Halon, Hitok Holohan versus Jakilku, Jachilku. Constitution Amendment Act declared under Constitution Amendment Act. Seventh Amendment. Allowing ruling L.C. Loklak Nath, the state of Punjab. 25th Amendment. Keshavananda Bharati Sri Padma Lal Varu, which is the state of Kerala. 32nd Amendment. Samba Murthy, which is the Union of India. And 36th Amendment. Indra Nehru Gandhi, which is Raj Narain. And Article 368 Minerva Limited, which is Union of India. First and second amendment Hikoto Holohan, which is Jacques Chilou. Treaties as a human rights. The most remarkable institution developments in human rights has been evaluated in the international multilateral treaties region, which approach the monitoring body assist at the time of the only previous World Conference of Human Rights held in Tehran in 1960. It's a single human rights treaty body exists. By the time the World Conference in Vienna, several treaties bodies has come into existence. Under the several treaties, named International Sovereignty of Civil Political Rights, 1977, International Covenant of Electro Economic, Social, Cultural Rights, and Conviction of Suppression, Punishment of Crime of the Crimes of Apartheid, 1973. The contravention of elimination of discrimination against torture and the conviction on the rights of child 1987 time of Millennium Conference 1916 168 stages parties on the treaties were placed into monitoring procedure. Voidness of existing law. Article 13 of Clause 1 provides existing law which clause with the rights of the fundamental rights conferred in Part 3 of Constitution shall so extend to be void. Case of another status Bombay. But there is not a wide opinion issue existing law which is inconsistent with any provision of the Part 3, rendering void only be affected the commencement of the Constitution. Effect from the Constitution. Dr. K. Nabhirai with the State of Mysore, Panal Biniraj with Union of India, Rabindra with Union of India. What they say? But they are not void ab initio. So the voidness in existing law. Article 3 provide existing law which is clash with the excess of the fundamental rights prefer in the Part 3 only. So Part 3 of Constitution says that about fundamental right which exists of if that is clashed with the existing law of the existing law provided by 13 okay 13 class 1, then it extends to be void. So it is void when it's classed with existing law, it is void, but it's not a void of an issue because why they say existing law which is inconsistent on the provision of Part 3 render void only the effect of commencement of the Constitution. So from the day of Constitution, so that 94 from the Constitution it is void, okay, but there is not a void of an issue. D.K. Nambira which is State of Mysore, Panal Biniraj which is Union of India, Rabindra which is Union of India. Inconsistent with the law. Supreme Court can strike down a law only if there is a clear constitutional violation, not a mere because of falling into disuse or becoming perception of society has changed regarding the registration of purpose and need of the law of question. So Supreme Court will strike off the law. When they will strike off the law, when the perception of the society has changed regarding the legitimacy or purposes, when there is a change in the society's view and need the law in question, then there is a question of law. What is that? Why this law? Such kind of thing is there. Supreme Court can strike down the law. The clear constitutional violation should be there and not merely because falling into dispute. So even though the people say they have a perception, different perception, and they need the question, what the question of law they can't change, but only in the clear constitution violation. When there is a clear constitution violation, they can strike out the law, not on other means. Working of act. How the act has been worked may be looked by the assessing validity. So something is to be validated. What is validated? Assessing that how it is being validated, we can come to know how the act works. Charan La Shadu. Something has been done. It is done as per the act. That is how the act works. It should be done this way. It can't be done another way. That is the way assessing the work. Right to equality. Equality of law. A state shall not deny any person equality before the law or equal protection of law within the territory of India. Everyone in India, within the territory of India, they are under the equal protection of law. And any person, no person can be denied on equality of law. Article 14, equality of law. Notes in Article 14 promotion merit cum seniority. There is a sharp distinction between merit cum seniority, seniority cum merit. In this case, the merit has given a preference over the seniority. UV Mahadkar versus Subhash Anand Chandra. Yeah. Administrative decision. The decisions, administrative decision should contain all the reason which prevails on the official decision to arrive at its conclusion. No authority can permit to travel beyond the state of adoption. The expression by it is impelled action. State of Punjab with us, Bandip Singh. So they can't go adoption prevailed on official decision to arrive in the conclusion. No authority can permit it to travel beyond the stand adopted and expressed by it by impugned action. So every administration action to be under the law and as per the law, no one can go for a fast forward own justice. Compensate compassionate appointment. The compassionate appointment cannot be granted on a post with or which the candidate is ineligible. So only a eligible candidate can be appointed for this compassionate appointment. Legitimate expedition. The doctrine of legitimate expedition cannot be applied in the case of invalid expedition. Expectation. Legitimate expectation. Doctrine of legitimate expectation cannot be applied in the case of invalid expectation. That should be a valid expectation. Invalid expectation can't be applied. Okay. Doctrine of pro that is state of Uttar Pradesh, which is state of Union of Bank of India. Doctrine proportionality. A determination of final cost of land is a dispute shall be in consonance with the doctrine of proportionality, but not on the basis of market price, which is arbitrary or unfair. Emma, the determination of final cost of land is a dispute shall be in consonance with the doctrine of probability, but not on the basis of market price, which is arbitrary and unfair. Madhya Pradesh Housing Infrastructure Development Board, which is BS Barihar, and Tamil Nadu Housing Board, which is Service Society. Probability.